Three police officers accused of killing Eldorado Park teenager Nathaniel Julies will probably know their fate today if they will be released on bail. Let's go there now live.
Straight up, you can see.
Thank you, Worship. I still confirm that I stand before you on behalf of applicant number 2. Yesterday, before we adjourned, my address entry point was that I am of the view at this stage that applicant number 2 has successfully proven in the case that exceptional circumstances exist here in which in the interest of justice do permit his admission to bail. And Your Worship, I wish briefly just to indicate that the legislature has defined, and also later on the courts were guided by the Superior and the Constitutional Court, that exceptional circumstances are unusual facts in the matter, which locations is found both in the case of the state and in the application of the applicant. We submit that the failure by the state, notwithstanding or despite certain admissions which have been made by the applicant number 2, the failure thereof by the state to counteract those admissions. This is against the background that an accused before you has got the right to remain silent, is presumed innocent until proven guilty. Applicant number 2 deliberately waived those rights in order to play open arms to the court and tried to furnish a brief explanation. That explanation, as we stand, Your Worship, it remains unchallenged. On the other hand, the state, it did not read any single witness statement. This is very important. The state did not read any single witness statement. It's like the case against the applicant is made out by the investigating office. The question is, if the state have got a strong case against the applicants, why do they fail to bring these statements before the court so that the court analyze those statements as against the versions of the applicants? I submit, Your Worship, that's an exceptional factor. An exceptional factor is a factor that is out of the ordinary. It doesn't usually happen that an applicant will do or go an extra mile in order to show to court that this is how open I am, I'm not guilty to this extent. Applicant number 2 have done that, Your Worship. And Your Worship, for authority, it's the case of S. Skitekat, S. Ndlamini, Jobet, and Jonas, whose citations, because they are so rampant in our court-decided cases, it will be easy to locate them, Your Worship. Your Worship, the other main argument for the state to oppose bail is on the alleged basis, which I found to be extremely baseless. It's not supported by the facts. Is that all the applicant acted in common purpose. Now, fortunately, after adjournment, I will say my colleague, because of having presented this issue, gave me an assignment and I went to read about the doctrine of common purpose. And I could understand why there was perhaps a confusion. Your Worship, it's a commentary on cinema. It's a fourth edition. It's on page 265. It's under paragraph 1, 2, 3, under item number 11. It says common purpose and dollars in virtualis. Your Worship, I know this is it's an investigative and a criminal court, but because this aspect has been introduced, I need to counter and expose the fallacy of the state reliance method. For acts to have a common purpose with others to commit murder, it is not necessary that this intention to kill be present in the form of dolus directus. It is sufficient if this intention takes the form of dolus in virtualis. In other words, if he foresees the possibility that the acts of the participant with whom he associates himself with may result in wise death and reconcile himself with that possibility. Now, Your Worship, my learned colleague without facts introduced this subject. For this doctrine of common purpose to found any legal basis, they ought to have read out a statement that goes to the effect that we have planned that we go to a scene and go perhaps and kill whomsoever that we find in the scene. We do not have that scene. As to where does he construct and conceive this doctrine of common purpose, you don't understand. And besides, there were 5 occupants in the car, excluding applicant number 3. My instructions were: accused number 1 was the driver, applicant number 1 was the driver, applicant number 2 a passenger in the front, and there was a stall for seeing and Fisa at the back. Now, these other 3 are not before you. We don't have a statement to say, perhaps this one overheard these others that have been arrested, to say that this one planned to go and kill whomsoever at the scene. I'm basically discounting the fact that they could have planned that we'll go to the scene and when we reach there we'll find an innocent disabled person and then we'll shoot at that person. Now, those things are not there. It's not there. Now, instead, the state is sensationalizing the case, emotionalizing the case, and not focusing on the strength of the state case. They must bring the case before you. It's not the responsibility of the court to descend from the chamber into the state docket, because otherwise that will amount to a bias against the accused person. So, Your Worship, the issue of common purpose is completely out. Because let's look at it this way. Let's assume hypothetically that they acted on common purpose, which is far-fetched, which doesn't exist. So when does the common purpose end to exist? When does it cease? As soon as the victim is shot. It's non-existent, Your Worship, with all due respect. Your Worship, I will deliberately not comment on the statement of Ms. Harris. She's feeling pain. This case is emotional. All of us are affected emotionally, badly as a result of this case. The innocent life was lost unnecessarily. But where does the blame lie? Where does the blame lie? The blame lies in the dysfunctionality of the police services. Worship, I've explained to court that my client, since he joined the police, from the moment she took employment as a constable on the 12th of December to date, she has reported 4 different incidents of intimidation from the local drug lords in Eldorado Park. There has not been a report back that came to her to say, this is how far we've investigated. This is how far we think you can assist us in terms of submit a statement here. There's none of that. Your Worship, as regards the requirement, what is it? I echo my colleague's version statement to say that the court secret of statutes. Your Worship, the case can be said to be very strong. If you're not presented with incriminating evidence, there's nothing you can do. It's not your fault. To this end, Your Worship, I echo my colleagues' statement that the provisions of Section 60 subsection 4A to E.
Before you go that far, yesterday when you read the affidavit
Yes.
of applicant number 2 into the record, you mentioned this thing of drug laws. And I hear you still repeating it again today in your address. What is the relevance of these drug laws to the death of the deceased?
George, with your guidance, it may not be relevant. I thought, insofar as it's explained the dysfunctionality of the police service, the control, training and so forth, it could, if we had a proper functioning of the police services, the eventual unfortunate death of the deceased, this is my submission from the summation of what has been presented to me as an instruction that had there been a proper professional service, police service, the way the incident happened could not have happened.
So is she saying management at the police station in Eldorado Park failed to pursue cases of the drug laws? That is why she shot this innocent young fellow.
That's not what she's saying. I'm saying
Yeah.
there are 4 incidences thus far from the 12th of December to date about her being intimidated, arising out of a strict adherence to community policing and not wanting to take some bribe from the drug lords. In a way, you can take it further to say she's saying taking of bribes from the drug lords is very rampant at Eldorado Park. But I would recall back. That is not. I do not want to take the issue that far. But for the record, nothing by the management was done insofar as to pursue that investigation. Was that it been pursued? Perhaps they could have come back in their management meeting and say, "This is how we come up with an intervention." Your Worship, if I may proceed, I was still saying, I echo my colleagues' views immensely that in respect of the provision of Section 64A, paragraph A to E, the likelihood of the applicant evading or absconding standing trial, it's non-existent. It's unlikely, it's unrealistic to mention that upon conviction, because the offense is grave, they are likely to get a lengthy sentence period in jail, and therefore will serve that as an inducement to run away from trial. It's not borne out by the facts. It's not borne out by the facts. Applicant is not a flight risk. She has cooperated thus far with the police. You see, the fact that the court may not have the full background information as to what exactly happened, it's on account of the state not wanting to open up its shoulders to court. We may want to discount it. I said to, and I'm saying this because if you were to stand up and want to introduce that kind of evidence, we would object. Otherwise, this bail application preliminary inquiry will not end. I take instruction from client. Client tells me, look, I've cooperated with the police. This is what I've done. I've tried to tell them wholeheartedly, out of a guilty moral conscience that I feel, that my hand caused the death of the deceased. But objectively looking at that statement, applying the law, the state would not be able to run along with it until it proves an intentions against the accused person. So, the accused the applicant has proved that she's cooperated with the police. They drag her in collaboration with the police to go and make so-called a confession statement. But surprisingly, why is it not being brought before you? The applicant does not have previous conviction, he doesn't have pending cases or outstanding warrants we have mentioned all those. So, I wouldn't want to repeat there, Your Worship. We challenge the state, we say to the state, you do not have a basis for you to continue to ask the court to keep these people in jail. And besides, Your Worship, it is the purpose of arrest is to require the attendance of the accused in court. That is the purpose of the arrest. So, accused have been arrested. The court is determining whether they will be able to come to court. We are submitting that they will indeed come to court because there is nothing in law and in law that suggests that they will run away from standing this trial. The state also tries to drag the issue that there's a rioting at Eldorado Park community. Yes, of course, we know that has happened, and we know as we come to court there are people placating outside. But Your Worship, what does the law say? Let's put it differently, Your Worship. This is very serious. So if we go along with the argument of the state, it means tomorrow if they come here and say Magistrate Muhango must descend from the bench, that means he must descend and come down. So it can't happen that way. It can't. We have got the law in the country. The court is guided by the law. You are a creator of statutes. You apply the law.
Is there anywhere where members of the community are dictating to the court not to grant bail?
At the court?
I say, is there any way where community members are dictating to the court not to grant bail? Or is it not a factor which the court can take into account?
No, it's a factor which the court can take into account, but of course that has to be taken in cognizance of what the law says. Your Worship, I've been in this court for more than 15 years. We have had instances of the state versus Maruhanye and the state versus Maruhanye and others. This matter was before this court. When people marching outside, the late learned and brilliant presiding officer, Magistrate Orient, notwithstanding what was happening outside, he did not allow himself to be influenced by that, but he applied the law. To a certain extent, we need to educate the community about the law. If we allow the law, if we allow people not to observe the law, we will not have any rule of law in the country. And this institution is codified in the Constitution, it is enshrined, it is independent, it is fearless, it operates without fear or favor. There was also a complaint in Indonesia. I'm mentioning matters that were within the area of this court before Magistrate Fenter in Indonesia. There were matches there, but She applied the law and said, this is what the law says. It is not for me to punish the accused by refusing them bail in anticipation of a custodial sentence. That would be a trial court to do. And I think this, as I mentioned, that reminds me of the state versus the Achason. I'm just going through my notes if I want to. The state versus Achason, the 1991 volume 1, the South African law report. I think it is an appellate division. Yes, Judge Mohammed sitting, no, it's my correction, it's a Namibian decision in 1991 volume 1. Judge Mohammed remarked that an accused person cannot be held in custody solely in anticipation of a punishment unless the interests of justice are prejudiced. Now I'm saying, objectively speaking, what interests of justice will be prejudiced when the accused come to court? I mean, when accused are admitted to bail, they will attend trial. The way this case is so clear is such that I'm trying to think which bail conditions can be imposed. Because the imposition of bail conditions is also not done for the sake of it. It has to address a particular legal issue. I'm saying what legal aspect if we were to request you to say no, impose bail conditions. If they will attack from, as my colleague says, if there will be people who want to attack the family of the applicant number 2, those are the people that must be arrested. So that we reinforce the rigidity, the strength, and the supremacy of the rule of law in the country. Your Worship, I may also say that it's unfortunate. The NPA has constructed an extremely poor case. Which case, as we go much deeper into it even borders one even to think that it is almost non-existent. Because who's going to testify in respect of so that they are able to prove the intentions of wanting to kill the deceased? There's no one. Just a minute, Your Worship. Your Worship, I was recording the proceedings and when I reached home, I replayed the recordings. When my learned friend, my colleague, was reading the affidavit, that is the statement that is an opposition statement that the accused should not be admitted to bail. In one clip he says, I submit that applicant formed part of a group of people acting with a common purpose. With a common purpose to wit crime prevention, and then developed and formed an intention commonly to go and commit murder. It's not borne out by the facts. And in law, Your Worship, there cannot be a common purpose that is constructed out of a lawful crime prevention. Because when they went out, they were lawfully booked out. Now, we are not explaining when did all of a sudden now that common purpose to go and do crime prevention now turns around to become an unlawful common purpose, which will then attribute and impute to any of the parties present into the commission of the offense. Now, Your Worship, we submit that the incident happened at night. My client is not the one that booked out the firearm. Your Worship, I was even also trying to think if she were to be convicted at worst or most, which element in the form of ulpa is it if we subdivide mens rea, will it be dolus, directus, or dorus in virtualis, or will it be negligence? Because dolus in virtualis and negligence, the difference, it's the distinct, it's a thin line. Now, it would be argued even during trials successful to say, could she have had a foreseeability that if she fired a rubber bullet, that will cause the death of the deceased? With what we have thus far, I'm confident if the state does not do much, the state may not be able to secure any conviction, notwithstanding all these admissions that have been made. So, the state case is weak, it's extremely weak, to a point of being construed as non-existent, and to that length, in the state versus Chawalala, the court decided that when the state case is weak, that is an exceptional factor. In fact, Your Worship, we need not prove numerous exceptional factors. One factor proven was decided in the avalanche of cases to be sufficient, so that the next leg should be, the next inquiry is whether the accused should be, whether it's the interest of justice that they should be admitted to bail. And an inquiry is held with regard to the provision section 60 4A to E, insofar as to assessing the interest of justice. And I submit that none of that. My colleague goes to the extent of saying the accused's life is at risk. Lordship, we submit with due respect that he's not being honest. Worship, unless if there is any other aspect that I did not address you on, that will be my submission.
Why did she shoot the deceased?
Your Worship, my instructions are that she shot to
Because you see, initially the impression I gathered is that probably there was a service delivery protest, or maybe there were people running around, or but from the facts presented by the state, it appears this young boy was alone next to this truck. Now I'm at pains to understand why this young fellow was shot. See, I thought in your address you'll help me to understand and place factors why I should admit her to bail. But now I realized you're concentrating more on aspects which should be canvassed at the trial, other than factors which must be placed before me, why I should admit her to bail.
Yes, Your Worship. Thank you. Your Worship, it's clear from the facts that are before court already, when she took out the fire and shot at the deceased, she meant to scare the deceased. She did not mean to kill her. Hence, in our affidavit, we say we do not have the requisite mens rea, that is a criminal intent to cause the death of the deceased. It was meant to scare, and she labored under the impression that the same firearm was still loaded with pellets as had been previously safely used at Eldorado Park without any fatal incident. It was loaded with rubber bullets. That evidence is not being challenged. Unfortunately, at the scene, unbeknown to her, this firearm was now loaded with live rounds, and when she fired it, she caused the death of the deceased, unfortunately. Based on these facts, and given these admissions, the state, having been given an opportunity, it did not challenge that version. That version remains unchallenged, as it stand before. So it is on that basis that we say the actus reus at the time should not be looked in isolation of what had happened at Eldorado Park and what she intended to do by firing this lethal shot at the deceased, which unfortunately caused the ultimate death.
You mentioned yesterday that applicant number 1 is threatening number 2 with death.
Yes.
Now, if she's out on bail, won't number 1 go and kill her, as you mentioned yesterday?
Your Worship, I would have to say it here, but I thought we would not disclose it because the courts want to find out, and then I will have to address it. Your Worship, the applicant number 2 is currently being held at a secret venue because of acknowledgement on the part of the state that she has received death threats. But Your Worship, to keep her in custody in lieu of the protection of her life, Your Worship, if the threat is so serious against her life, Your Worship, I guess we will get instructions to approach the police. But we don't have that instruction at the moment, and we do not think that was mentioned as part of trying to demonstrate that when the trial court will come and decide on a conduct, it will most obviously have also to consider how she reacted immediately after the incident.
In fact, if I were to sum up my question, is that don't you think that if she's kept in custody, it will be safe for her, other than to walk about in the street where she can be attacked and be killed by applicant number 1, as you mentioned yesterday?
No, Your Worship, we do not think so. Incarceration on its own is a punishment, and it should have been punished for observing the law. That means our society would have now deviated from protecting people who are observing the law against those that are disrespecting the law.
No, it's true.
As a court basis.
Thank you, sir.
Thanks, Your Worship. The first issue that I want to address before this court is the issue of the schedule, Your Worship.
The issue
of the schedule of offense in which the applicant number 3 is facing, Your Worship. Your Worship, the defense is of the view that accused number 3, the offense in which he's facing, it has to be schedule number 1. And then I will read it on the CPA, Your Worship. Under schedule 1. Any offense except the offense of escaping or from lawful custody in circumstances other than the circumstances referred to immediate under the punishment wherefore may be a period of imprisonment exceeding 6 months without the option of a fine. Your Worship, I don't think that the charges in which he's facing, Your Worship, is it Schedule 6 offense, Your Worship. It's assessed after the facts, defeating the ends of justice and possession of unlicensed ammunition, Your Worship, like ammunition, Your Worship. Your Worship, but however, I will leave it to the court to make a ruling with regard to that aspect, Your Worship. I'm just addressing it, Your Worship. But however, it will be the court to decide, Your Worship, with the issue of the schedule, Your Worship. Your Worship, there is no concrete evidence, Your Worship, especially to the applicant number 3, which shows that indeed on the day in question, Your Worship, he did taper with the investigation at the scene of the crime, Your Worship. Your Worship, he was off duty on the day in question, applicant number 3, and then he was called by the applicant number 1, while they were, applicant number 1 was in bar, Your Worship. So, good question to ask. What happened at the scene of crime while applicant number 1 was at home? Applicant number 3 was at home. What was happening at the scene of crime? No problem, let's go further. He decided to go to bar to meet his colleague. What was happening again at the scene of crime? After Your Worship, you have the discussion with his friend, Your Worship. At a later stage, he went to the scene of crime, Your Worship. Your Worship, and on the day in question, there were Sergeant Warrant Officer Nechkweta, he was on duty. There is no evidence from the state side stating that due to the accused applicant number 3, it was difficult for him to construct evidence at the scene of the crime. There is no such evidence, Your Worship.
Was he not off duty?
He was off duty, Your Worship.
Now, why did he want at the scene of crime?
Your Worship, Your Worship, what happened is that after this shooting happened, applicant number 1, he called him to come and assist him to report the matter to the police station, in which he did. He called his commander, Your Worship, on the day in question, telling them about what happened. About his murder, Your Worship.
My question is, in my understanding of your submissions, applicant number 3 was sick, he was off duty. But there are other officers present at the police station. Number 1 does not call the people who are on duty. He decides to call his friend who's off duty, who's sick. And here he comes, he runs to the scene. Why? Didn't he find it important that those who were on duty should be informed about what happened, so that they can go and secure the scene, other than him who was sick?
Can you approach, Your Worship?
Yes.
Okay, Your Worship, I've taken the instruction, Your Worship. Your Worship, Reason being that there were duty officers on the day in question. But after the incident, there was no person who was attending the scene of crime, Your Worship. Then, applicant number 1, when he called him, Your Worship, it was for the accused applicant number 3 to assist him, Your Worship, so that he can report the crime, Your Worship. He can inform the duty investigating officer also, Your Worship, about the incident, Your Worship. And then, Your Worship, he did visit the scene of the crime, Your Worship. And then in which, Your Worship, he got those 2 bullets from one of the community member was present there at the scene, Your Worship. But Your Worship, again, what did he do with those two bullets, Your Worship? He took them to the police station and they were booked. For him taking those 2 bullets to the police station, was he defeating the ends of justice, Your Worship? No. Your Worship, accused number 3, Your Worship, he doesn't have any reason, Your Worship, to benefit from the crime which happened on the question. And in Your Worship, when this incident happened, Your Worship, it happened while he was off duty, but it emanated from the accused number 1 and number 2, who were on duty on the day in question. They drive along the Eldorado Park and then go to Freedom Park. And they came back, Your Worship, to the Eldorado Park where they were this track that we are talking about, Your Worship. And then, Your Worship, good question to before this court is that, Your Worship, they said that at first this child who was peeping along next to this trailer, they chased him with a siren. The child departed and come back at a later stage. It's when they okay, I will withdraw those as submission, Your Worship. But my submission that at all material stage during the commission of the crime it was not there, and it was not part and parcel of the commission of the crime. And then the issue of common for purpose, Your Worship, it can't gel, it can't fit for him, Your Worship, to stand, because, Your Worship, if it was planned, Your Worship, he was not there at all. And then during the end result of the commission of the crime, Your Worship, still he was not there. He just emerged after when he was helping by reporting the incident.
You see, unless if I don't understand these issues quite correctly, you see, I'm under the impression that if you are booked off sick, it means you can't go to work. You must be at your house. Now, he's booked off sick. He's phoned by applicant number 1. He leaves his bed and rushes to the scene. And here he appears before me charged with defeating the ends of justice. That's where I find it difficult for me to understand. Because in your submissions you say he did not commit any offense.
Yes, Your Worship. Your Worship, the facts that I want to lay before this court is that, Your Worship, I do agree that he was booked off sick. And then he was called by his co-accused, by applicant number 1, to come and help him, Your Worship. Okay, why he was called to help him? A good question to ask, Your Worship. And then the answer is, Your Worship, applicant number 1 was shocked. And then he needed an assistant for this matter to be reported, Your Worship. And on the day question, this matter being reported, yes. Applicant number 3 is the one called the duty officer on the day in question, his commander, informing them about what transpired.
Now, if he's admitted to bail and is outside, what guarantee do I have that he won't go back to the scene there?
Well, there you go. The bail application of the 3 police officers accused of killing 16-year-old Nathaniel Julies in Eldorado Park. We earlier heard from the lawyer of accused number 2, Kayleen Whiteboy, and he was saying that the state's case is extremely weak and saying this is an exceptional factor when arguing for bail. The magistrate asked him, why did she shoot the deceased? And he replied, when she shot at the deceased, she meant to scare him, not to kill him. And so that's basically in a nutshell what the lawyer for accused number 2, Kayleen Whiteboy, had to say. Accused number 3's lawyer is currently arguing before the magistrate. We'll try to get back there as soon as possible. But I want